Imagine this. A new, groundbreaking law comes into effect, promises everyone incredible new rights, new freedoms,
Yeah.
a huge step forward.
Yeah, sounds great.
But then you have to ask, right, what about the cases already going through the courts? Do those old rules, maybe unfair rules, still apply? Or do people get the benefit of the new protections straight away?
That's the million-dollar question in legal transition.
Well, today we're diving into a really pivotal South African legal case,
Yeah.
SV Mhlungu and 4 others. It went to the Constitutional Court back in 1995.
Very important one.
And it grappled with exactly that question, deciding how South Africa's brand new constitution and its powerful Bill of Rights would apply to trials that were already underway when this whole new democratic era began.
Mm-hmm.
And look, this wasn't just some, dry legal technicality.
That's far from it.
It was about whether potentially thousands of people would get access to fundamental human rights, or if their fate would be sealed by the laws of the past, even if everyone agreed those laws were unjust. It's a deep dive into how a nation tries to make a real break.
And what's so fascinating, I think, about Mhlungu is how it became this battleground for interpreting one specific, crucial, and frankly quite tricky transitional rule in the new Constitution, Section 241(8).
Right.
It basically forced the court to confront the very soul, the spirit of this new legal order they were trying to build.
So our mission today: explore the core legal issues, unpack the really powerful arguments from the different judges, because they didn't all agree.
Not at all.
Look at the court's final reasoning, and crucially, the lasting impact of this landmark decision. We want to make this complex case engaging, accessible, whether you're just curious or maybe a law student needing to get your head around it.
Let's do it.
Okay, so let's get into the heart of the problem. The new Constitution of the Republic of South Africa comes into effect April 27, 1994. Huge moment. Democracy, a new Bill of Rights, that's Chapter 3.
A fundamental shift.
But tucked away in the transitional bits was this one clause, Section 241(8).
Right.
And it caused, immense confusion.
Understatement, yeah.
Let me read it out clearly for you. It says, all proceedings which immediately before the commencement of this Constitution were pending before any court of law shall be dealt with as if this Constitution had not been passed.
As if this Constitution had not been passed.
Yeah, just let that sink in. So the central question for the court was, what does that really mean? Does it literally mean ignore the entire new Constitution, including all the rights, for these ongoing cases?
Or something else entirely. It sounds simple, but the implications were enormous.
Exactly.
And the practical problems hit almost immediately. There was another very recent case, SV Zuma, which had just invalidated part of the old Criminal Procedure Act, specifically Section 217. Now, this old rule, it basically put the burden on an accused person to prove that their confession was not made freely and voluntarily.
Wow, okay. The burden was on them.
Yes, which, of course, directly clashed with the new Constitution's right to a fair trial, which puts the burden firmly on the state.
Right. Innocent until proven guilty.
Precisely. So if you took Section 241(8) literally as if this Constitution had not been passed, it meant people whose trials were already pending would be stuck with that old unfair confession rule. They wouldn't get the protection of the new fair trial right, even though the Constitution was now the supreme law.
That seems fundamentally wrong.
Well, Justice Muhammad certainly thought so. He vividly pointed out what he called the unjust, perhaps even absurd consequences of reading it literally.
Give us an example.
Okay, imagine the scenario he painted. Two people, accused of the exact same crime, same incident. One gets indicted on April 26, 1994, the day before the Constitution. The other gets indicted just 2 days later, April 28th.
Okay, tiny difference in timing.
Tiny but potentially huge consequences. Under that literal reading of 241, a court man and person one indicted on the 26th, their case is pending. So they could be convicted based on a confession they maybe couldn't prove wasn't coerced because the old unfair law applies.
All person two?
Person two, indicted just after the Constitution came in, gets the full protection of the new fair trial rights. The state has to prove the confession was voluntary. Same crime, same facts, potentially opposite outcomes based purely on the indictment date.
That's absurd.
And he raised another stark point. Someone charged under an explicitly racially discriminatory law before April 27th could, under this literal view, still be convicted after that date, just because their case was pending. It flew in the face of making, as Muhammad put it, a ringing and decisive break with a past which perpetuated inequality.
Wow. So you can see why the lower courts were in such a state before the Constitutional Court got involved. What was happening on the ground?
Oh, it was chaos, basically. Judges across the country were wrestling with this Section 2418, and they came up with completely different answers. A real legal muddle.
What were the main lines of thought?
Well, broadly, three main approaches emerged down in the provincial courts. First, some judges tried a really narrow reading. They said 2418 only preserved the court's physical jurisdiction, its power to sit and hear the case in its area.
Okay.
But, they argued, the new Constitution's rights, the substantive rights in Chapter 3, still applied to how the case was decided. They were trying to limit 241 as much as possible.
Trying to let the rights in. What was the second view?
The second approach tried to split hairs, essentially. They distinguished between procedure and substance. Maybe, they thought, the old procedures apply, but the substantive fundamental rights, like the right to a fair trial, those should still apply from the new Constitution.
That sounds tricky to apply in practice. What's procedure versus substance?
Exactly. It's often a blurry line, a complicated tightrope walk, as you say. And then there was the third view.
Which was?
Much more rigid, complete exclusion. These judges looked at the literal words as if this Constitution had not been passed and said, well, that means what it says. The Constitution is entirely excluded from pending cases. Full stop. If your case started before April 27th, you were stuck with the old law, good or bad.
It's fascinating, isn't it? These different takes really show the struggle. How do you balance the seemingly clear text of this one transitional rule with the huge aspirational goals of a new Constitution meant to fix past injustices?
Precisely. The lower courts were right in the thick of trying to figure out the very identity of this new legal system.
So eventually, with all this confusion and conflicting rulings, it lands squarely in the lap of the new Constitutional Court. What happened then? Did they find it any easier?
Well, easier, no. It led to a pretty sharp division among the top judges themselves. Two main interpretive camps emerged pretty quickly.
Okay, who are they?
On one side, you had Acting Justice Kentridge. He argued strongly for a literal interpretation. Interestingly, he first made a technical point, arguing the court wasn't actually supposed to be deciding the 2418 issue in this specific referral.
Oh.
Yeah, but the rest of the court basically said, look, this issue is way too important publicly. We need to settle it now. So they decided to tackle it head on.
So what was Kentridge's main argument on 241 itself?
His reasoning was very much focused on the literal words, shall be dealt with as if this Constitution had not been passed. He pointed out that similar phrasing had been used in previous laws, like the Interpretation Act, and it usually meant proceedings just continue under the old rules, as if the new law changing them didn't exist for those specific cases.
So continuity and legal certainty were key for him.
Absolutely. He acknowledged that this would lead to those anomalies we discussed, the unfair day before day after scenarios. He saw them as, essentially, the inevitable result of a transitional provision. A price, he argued, the lawmakers were willing to pay for an orderly transition and to avoid disruption. For Kentridge, the Constitution is a legal text, and you have to respect its clear language. To do otherwise, he famously suggested, would be divination, not interpretation.
Strong words, so a very text-focused, perhaps formalist approach.
You could say that, yes. Prioritizing certainty and the plain meaning of the text.
Okay, so that's one side. Who represented the opposing view?
That was primarily Justice Muhammad. And right from the start, he flagged his profound difficulties with Kentridge's literal approach.
What were his main objections?
Muhammad's core argument was that the literal reading led to those unjust, perhaps even absurd consequences that fundamentally undermined the whole point of the new Constitution. It's very spirit and tenor, he said. He just couldn't accept that Section 241 was intended to strip people of fundamental rights.
So how did he interpret it then?
His view was that the purpose of Section 241 was much narrower. It was purely jurisdictional, meaning it was just about confirming the authority of the existing courts, the courts set up before 1994, to continue hearing cases after the new Constitution came in. It ensured the courts themselves could keep functioning legally, but crucially, it did not dictate what law those courts should apply once they were hearing the case. It was about who hears the case, not which rules they use.
Oh, that's a clever distinction.
It is. And Muhammad didn't pull his punches on the wording itself. He described the key phrase shall be dealt with as colloquial, flabby, and uncertain. Flabby.
Yeah, quite evocative for a legal judgment. He contrasted it with clearer terms like continued and concluded, found in other laws that explicitly did preserve old law for pending matters. He also stressed that Chapter 3, the Bill of Rights, is all about expanding rights, not restricting them.
What about Kentridge's point about avoiding disruption?
Muhammad addressed that directly. He acknowledged there might be some practical issues if the new rights applied immediately to all pending cases, but argued these could be sensibly managed by judges. And, more importantly, any such disruption was far outweighed by what he saw as the plainly untenable denial of fundamental human rights that the literal reading caused. He advocated for a generous interpretation, giving the widest possible amplitude to the rights in the Constitution. It was definitely a more values-based approach, a very different judicial philosophy on display there.
Completely. Text versus purpose, certainty versus justice, in a way.
So Muhammad wrote the majority judgment favoring the purposive approach. But you mentioned other judges agreed with his conclusion, but maybe for different reasons.
Exactly. The concurring judgments add really interesting layers. Take Justice Kriegler. He came at it from a slightly different angle.
How so?
Kriegler basically argued that everyone focusing so intently on Section 241(8) was asking the wrong question. For him, the 1994 Constitution wasn't just another law, it was a fundamental metamorphosis of the entire legal and political system. It created powerful, enforceable, fundamental rights for everyone.
So 241(8) was minor in comparison.
That was his view. He called Section 241(8) an obscure subsection of a prosaic transitional provision, almost dismissing it. Its real limited purpose, he believed, was just to say which courts, the old courts, would handle the pending cases, not what law they should apply. He expressed profound disbelief that the Constitution's framers would have sneakily, surreptitiously denied fundamental rights to thousands just because their cases were already in the pipeline.
A very strong rejection of the literal view. And then you mentioned Justice Sachs.
Yes, Justice Sachs. He brought a really compelling, almost philosophical dimension to it. His approach was about reading the different parts of the Constitution together.
Harmonizing them.
Exactly. He said you can't just look at Section 241 on its own. You have to read it simultaneously with Chapter 3, the Bill of Rights, and understand their relationship. And he used this incredibly vivid analogy.
Which was?
David and Goliath. He argued that a puny provision, like Section 241(8), the transitional clause shouldn't be allowed to annihilate the powerful provisions that make up the heart of the Constitution, namely Chapter 3.
Wow, that paints a picture. David, the small technical clause, versus Goliath, the mighty Bill of Rights.
Precisely. He strongly advocated for a purposive and mischief-orientated reading, looking at the purpose of the law and the problem it was trying to solve, rather than a dry, literal one.
Yeah.
He emphasized the court's duty to uphold fundamental rights. He argued the unfairness, the incongruity didn't come from the transition process itself, but from the way you chose to interpret the clauses.
So how did he make 241 and Chapter 3 fit together?
Effectively, he reread the phrase, shall be dealt with, as if this Constitution had not been passed, to mean something like, shall be dealt with by the existing courts, subject to the provisions of Chapter 3. He essentially read the Bill of Rights into the transitional provision, ensuring the fundamental rights prevailed.
Okay, so after all this intense debate, these different perspectives, how did the court actually rule? What was the final decision?
Well, the majority sided with Muhammad, Kriegler, and Sachs. The purposive approach won the day.
So fundamental rights did apply to pending cases.
Yes. Muhammad's judgment laid out two key declarations. First, Section 241(8) does not stop an accused person from relying on Chapter 3, the Bill of Rights, in proceedings that were pending just before the Constitution started.
Okay, that's clear. What was the second part?
Second, it specifically dealt with that confession rule from the Zuma case, Section 217b2. The court declared that its invalidation applied to any criminal trial, no matter when it started, as long as the final verdict was, or might be, given after April 27, 1994.
It's a retrospective effect for that specific ruling.
In a practical sense, yes, for any ongoing or future verdicts. It drew a line based on the verdict date, not the start date of the trial.
That also had a huge impact immediately.
Profound. It meant the promise of the new Constitution, especially those crucial human rights, wasn't just for future cases. It reached back, in a way, to protect people caught in the transition. It ensured a more equal application of the law right away and stopped those absurd potential injustices we talked about. A massive win for human rights at a critical moment.
And looking at the bigger picture, what's the lasting significance of Mhlungu?
I think it really cemented the purposive approach as the dominant method for interpreting the South African Constitution. It sent a clear signal. The spirit, the values, the fundamental principles of the Constitution, especially human rights, will guide how it's applied, even if you have seemingly contradictory wording in, say, a transitional clause.
So substance over form.
In many ways, yes. It was a powerful declaration that the new legal order truly was that decisive break with the past. It ensured the core principles of democracy and human rights wouldn't be sidelined by technicalities or delayed. They applied broadly, immediately.
So when we boil it down, SV Mhlungu wasn't just about sorting out a confusing clause like 241(8).
Not at all.
It was really about making sure that the foundation of South Africa's new democracy, that deep commitment to human rights and equality, was actually real for everyone, regardless of the fluke of when their trial happened to start.
Couldn't have put it better.
So what does this mean for you, listening? I think it's a really powerful reminder that even when society goes through huge changes, how the law is interpreted carefully, thoughtfully, can make sure the promise of a better future actually reaches everybody, not just some. It shows the real power of a constitution and judicial interpretation to reshape a nation.
And it definitely leaves us with a big question, doesn't it? When nations do go through these major legal or political shifts, how do you best balance that need for orderly continuity, Kentridge's concern, with the absolute imperative to deliver immediately on new rights and freedoms, Muhammad's focus?
Yeah, and what role does the philosophy of the judges themselves play in striking that balance during those critical moments?
It's a tension that plays out again and again in constitutional law around the world.
Well, we hope this deep dive into SV Mhlungu has given you some powerful insights into constitutional law, judicial interpretation, and how courts navigate these crucial moments in a nation's history. Until next time, keep exploring.